Good afternoon. I'm Debra Moskovitz. I am Assistant to Crown Attorney in the downtown Toronto Crown's office. I specialize in the prosecution of child abuse cases, which involves cases children under the age of 16 as well as sometimes under the age of 18, anything involving physical abuse or sexual abuse or child pornography cases, and I've been prosecuting those cases for the last 5 years, and I'm also the team lead of the child abuse team in Toronto.
And my name is Meredith Kirkland-Burke. I'm a social worker and child forensic interviewer based out of the Hospital for Sick Children at the Suspected Child Abuse and Neglect Program, and on a routine basis work very closely with police officers and child welfare workers at the Child and Youth Advocacy Center. So we're going to get started. This afternoon, Debra and I were hoping to offer some food for thought for those participating in the webinar related to completing second or supplemental child forensic interviews. A few months ago, I was at a conference. I was speaking with some police colleagues from another part of Ontario. And during our conversation, they raised the issue that in their jurisdiction, that there had been a decision for children to only be offered a single forensic interview in the course of a child abuse investigation. I know in Toronto, we quite routinely will do secondary or supplemental interviews. And then about a month ago, I was down in the States doing some training through the National Children's Advocacy Center. And again, there was quite a bit of discussion about what they term, the term they use for sort of second interviews are follow-up forensic interviews. So it seemed to me that and I hope I'm right about this, that there is quite a mix in terms of practice related to conducting second forensic interviews. And we thought it might be a good subject for us to bring to this group so people in their various jurisdictions can have these conversations and sort out what is best, for their particular communities. Just a quick word around terminology. When I'm using the term supplemental child forensic interviews, it's really synonymous with doing a second forensic interview in a situation where obviously there's a child abuse concern. The child's being interviewed initially with the hope of a single forensic interview, but for whatever reason, there's a decision to do a second interview. So this is a second interview done related to the same allegations, but an extension of that initial forensic interview. And I just want to distinguish that from some people might be familiar with the multi-session forensic interview approach used often down in the States. Or the extended forensic interview approach offered through the National Children's Advocacy Center, which is right at the get-go, the intention is to do more than one forensic interview with that child. That's not really what we're focusing on today. We really want to focus on the situation where the intention is to do one interview with a child, forensic interview, and then at what point and what criteria do people consider to possibly do a second forensic interview. So just a little skip back in time. I did my undergrad degree in history, so I always feel like I have to provide this sort of historical context. We know that the field 20, 30 years ago, the field of forensic interviewing was entering a very steep learning curve in terms of what we knew was the best way to talk to kids and obtain accurate and reliable information from them. And in doing so, we made many, many mistakes in our field, including repeated suggestive leading questions, using multiple interviews with a lot of those poor interviewing tactics. And, a very fair question that was raised a number of years ago was, can children be reliable witnesses? Can they actually give us accurate and reliable information when we talk to them? In 1995, Steve and Cecilia Maggie-Brooke published this book, Jeopardy in the Courtroom, which made us very aware of a number of limitations that kids do have with respect to their ability to provide accurate information. And we came to be very clear of the detrimental effect of misleading questions or approaches where we were insinuating we wanted certain kinds of responses from kids. And so today, after sort of 30 years of practice and research, we've sort of landed at a point in the child forensic interviewing field that we know that our approach needs to be non-biased, that we really need to be utilizing a hypothesis testing approach. So we're not going in to confirm what we think has happened. We are doing the interview to test a number of different possible explanations for that child's disclosure or the presenting allegations. We know the importance of open-ended questions to solicit narrative accounts from kids and avoiding leading and suggestive questions. I'm sure this isn't news to anybody who's been in this field or does interviewing. We really now have a good sense of sort of a best practice approach to child forensic interviewing. Through these years as well, we've sort of come to a point, and I would say probably more 5 or so years ago, where we felt that a single interview or single session interview approach was optimal. And there are some good reasons for that, and I don't want anybody to get us wrong to think that I think largely a single session forensic interview, child forensic interview, is our gold standard approach at this point. For these reasons, we know that it can really limit the possibility that interview bias creeps into our interview. If we spend less time with kids in the room, there's less chance that that bias is going to creep in, or any poor interviewing techniques. We also know that a number of these children that we speak to come to us with a trauma history, and the fewer times we need to speak to them about their traumatic experiences, probably the better in terms of them being able to not get distressed and regulate and so forth. And then we know a single session forensic interview avoids the issue of inconsistency among or between statements that a child will give us. This last rationale around that it accommodates limited resources, I think is more of maybe an argument you make in a US kind of context versus where we are in Canada with socialized healthcare.
Videotape statements of children are very important in the trial context. 715.1 of the Criminal Code of Canada allows the Crown to use a videotaped statement of a child and or witness as evidence in the course of the trial if certain preconditions are met. 1, the child, being the victim or witness, must be under the age of 18 at the time of the offense. The video recording must be made within a reasonable time after the alleged offense, and the victim and or witness must describe the acts complained of, and while testifying, the child, who is either a victim and or witness, must adopt the contents of the video recording. Once the child adopts the contents of the video recording, that video becomes evidence of the events described. 715.1 of the Criminal Code was enacted for essentially 2 primary purposes. First and foremost, it was felt that it was very, very important to get the best evidence. And in getting the best evidence, taking a statement from a child, whether it be a day or a few days or even a couple of months after the incident, would be a best recollection of the events and assist in the truth-seeking function, as opposed to the child testifying in court a year or 2 years later. We all know that adults, and most importantly, and even more so children, are able to recall events closer to the time that something occurred as opposed to weeks or months or even years later. An ancillary purpose a secondary purpose of using a videotape statement as evidence is to reduce trauma and re-victimization of the child. So in order to save a child from having to tell what happened to them to the court again after they've done so on the video, by using that videotape statement, we save the child from that re-victimization in the course of the criminal trial process. It's not an automatic that a videotape statement of a child will be used as their evidence in court. First of all, the preconditions that I mentioned must be met, but there is always a residual discretion of the trial judge, which means that it's very important that a proper statement be taken. It's important that the interviewer use non-leading questions, that the quality of the video and the audio of the video be proper, and that the interest and or motives of the person obtaining the statement is something else that is taken into consideration. These are only a few among several factors that are taken into consideration in determining whether or not a statement should be admitted as evidence of the child. One other factor to take into consideration, and one other use that can be made of a video, is at a preliminary inquiry. 715.1 of the Criminal Code allows a statement to be admitted as evidence at trial, and that is also a section in the Criminal Code that can be used at a preliminary inquiry. That being said, under Section 540 of the Criminal Code, specifically Section 547 of the Criminal Code, if a statement is considered to be both credible and trustworthy, that video statement of the child can be admitted as evidence at a preliminary inquiry. Once that video is admitted under 547, defense counsel must bring an application to cross-examine that child. And in some circumstances, it may be the case that the child never has to testify at all at a preliminary inquiry and will only need to testify come trial.
So back to the question of a single session child forensic interview or doing multiple interviews, second interviews, or supplemental interviews. And we're going to skip to the research world here to hear their thoughts on this. This is a quote by Gail Goodman and her colleague, published, I guess now 2010, from one of a research paper, where they quote that the problem seems to be that researchers have used designs in which they have mixed multiple interviewing with suggestible questioning, thereby confounding conclusions regarding which manipulation resulted in response errors. So the effect of repeated interviews or multiple interviews may have been wrongly interpreted in earlier studies, and baseline conditions, including only neutral questioning, varied with multiple interviewing, generally have not been tested. I had to read that 3 or 4 times myself to be exactly clear. But I think the bottom line is that there have the way that a number of research studies have been designed in the past has prohibited us from really understanding the impact that multiple or repeated interviews might have on a child's ability to give accurate and complete information, because in the past a lot of these research studies have paired multiple interviews with paired them with poor interviewing techniques as well. Now I will shift to the next slide. So there have been a few studies completed. These are field studies, not laboratory studies, where there has been some ability to get a better sense of how a second interview might impact kids' ability to tell us information. This was published in 2007, 40 kids, so a small sample, ages 6 to 13. And I'm not sure that we can see this as a true kind of second interview, but what they did in the study is they interviewed all these kids. They were alleged victims of sexual abuse. And at the end of the typical interview, protocol-based interview, they basically took a 30-minute break, and the child was allowed to draw or given materials to draw. After that 30-minute break, the same interviewer sat with the child again and asked them to tell everything that had happened, um, much as if they hadn't already asked that child that question. And in this particular study, what they found was on the second asking, after that 30-minute break, kids provided 25% of the information they provided was new, so was different than what they had initially disclosed, and that generally kids actually in their second retelling provided more central versus peripheral details that were forensically relevant, and that interestingly enough, the amount of original information that the kids originally disclosed in the first interview was typically not repeated in the second interview. So despite the limits of a webinar that we can't see you guys, I guess you can sort of see us, I do want to try to do a bit of an experiential exercise here. So I want this is your first interview. I want everybody who's listening to think back to July 1st, 2018. This is a national webinar. What binds us all together is our country. So back to Canada Day, July 1st, 2008, I want you to try to remember everything about that day, starting at the beginning of the day, all the way through the morning, midday, afternoon, evening, and night. And I would like you to jot down what you remember. And I'm literally going to give you about 15 seconds. Okay. I hope you were able to write some things down. A second study that has been published, again, a field-based study published in 2012, 56 kids where there were suspicions of sexual abuse, ages 5 to 14, interviewed by NICHD interviewers. That's a fairly well-known forensic interviewing protocol. What they did in this particular study is, again, they took these 56 kids, they did a typical protocol-based child forensic interview with them, ended the interview, took a break with the child still remaining in the room with the interviewer, and then said to the child, "You've told me what happened to you. Then we played, then we rested. Now please tell me again everything that happened to you from the beginning to the end as best as you can." And again, what they found is that 58% of the information that the kids provided on their second retelling was in fact new information. One more study here, and this is the last field study looking at impact of multiple interviews. This was 2008. These were a small sample of 19 kids, and these kids actually were kids with some form of intellectual disability. So there was quite a lot of variation within the population in terms of their ability to participate in the forensic interview. And what they did in this particular case is they did have two separate interviews done on separate days, on separate occasions with these kids. When they looked at the information that these kids provided in their second interview, what they found is that 42% of that information was an elaboration, so in an extension of what the kids had initially provided. Almost 40% of the information was new. 17% was repeated from the first interview, and then a small percentage, 2% of information was considered uh, information that contradicted the initial information. Now, a big kind of caution here with a lot of these field studies, one of the limitations of these studies is we don't have ground truth. So we don't know necessarily the accuracy of the information because we don't know what's happened to these kids. This is why we're talking to them. And that's what distinguishes it from doing lab studies when you can control an event and know an event and then judge how accurate kids are being. But I think the take-home message here from all these kind of field studies, these 3 field studies that I've shown to you, is that there seems to be some benefit for kids to do a second sweep of their memory, in that it does seem to provide kids another opportunity to provide elaborated or new information. And I think I might be wrong, but my suspicion is when people are thinking about doing repeated interviews or second interviews, one of the misgivings or concerns is that kids are going to contradict themselves and they're going to shoot themselves in the foot, and you're not going to, end up with a case that might be, prosecution worthy, that kind of thing. In this particular study, the contradicted information you could see was quite small. The other comment made by the study authors was there wasn't a lot of control around the forensic interviewing techniques as well. So these are really kind of preliminary studies to give us a bit of a sense. And now I just want to move to, so we've talked about sort of what the research world has to offer us around this question. I want to now talk about the field perspective. And this is like those of us who are in the rooms with the kids doing these interviews. I don't know how many times people have found themselves in an interview and Johnny all of a sudden starts, running around the room or jumping off the furniture, or Sally starts talking about the pink elephants on the ceiling, or you feel like you're going down a rabbit hole. Things aren't going according to plan, and things are shifting sideways very quickly. I think if you've been doing interviewing for any even small period of time, especially these little 3 and 4-year-olds, often people have some pretty interesting stories to tell. So with that, unfortunately I couldn't show a video clip just for confidentiality purposes and stuff, but this was a little 4-year-old girl that I interviewed probably about 5 or 6 months ago. And about 20 minutes into the interview, when she actually had started to provide some disclosure to me, we had to keep her pretty busy because she was like kind of 4-minute attention span for everything. But at one point she just looked up at me and she said, "That's enough talking. You can shut your mouth now." So I'm just telling you, it's better coming from her. But the issue is when we're going down these rabbit holes, when our interviews are going sideways, being able to recognize when that is happening. And so that might be the little girl that gets up on the wrong side of the bed, or the little boy who's very distracted by something in the room, the child that gets overstimulated, or the little guy in the far right here who just wants to have fun. One of my experiences is sometimes with kids in the room, sometimes, a lot of times, no, I shouldn't say a lot of times, but sometimes the one-on-one adult attention is super for some of these kids, and they want to stay in the room. They don't necessarily want to talk about the substantive issues, but they want to prolong the experience of having the one-on-one attention. So with that all being said, which kids might you consider, perhaps you already do consider, as candidates for a possible supplementary interview? And this list I have just generated on my own based on my own clinical experience. But I think these are our kids with limited attention spans. Obviously the 3 and 4-year-olds, because this is part of their wiring and their makeup at this point, that 20 minutes is often a lot. And as opposed to doing a 40 or 45-minute interview with a 3-year-old, two 20-minute interviews might be more developmentally appropriate for them. Kids who are significantly impacted and symptomatic from a trauma-based point of view, so kids who are feeling dysregulated, kids who are getting triggered, kids who are having, psychosomatic problems, because we're asking them to talk about potential traumatic memories and experiences. This is another group of kids we might want to consider a supplemental interview. And then kids with reluctance. So these kids might not be actively having trauma symptoms or being distressed in an interview, but they've weighed the risks and the benefits of telling, and they've decided that, it's too high a risk to tell. So they're able to tell, they're just not ready to tell. And the possibility of a second encounter, contact, interaction may be of some benefit for these kids. Kids with limited cognitive or language abilities. So these are kids who could be, it could be ASD, it could be speech and language issues, it could be an intellectual disability, it could be a range of different things. But often for these kids, they just simply need more time to process both questions that they're asked and responses that they're asked to give. And that lengthens out the interview and increases their fatigue level. Kids with mental health problems, who again are finding it very challenging to be calm and relaxed and cope in that kind of setting. And then kids who are presenting, and there are a number of possible things we need to ask them about. I interviewed a little guy the other day, and he came with a concern around sexual abuse by a family member, and halfway through the interview, he started disclosing a fairly complex, long-standing history of domestic violence in his house. And so I really didn't give the sexual abuse issue enough time because I was focusing on the DV exposure. And then lastly, kids who have perhaps unfortunately been in situations where there have been multiple offenders. 5 or 6 years ago, I interviewed a 6-year-old girl, and again, unfortunately, there were 5 suspects in that case. In the course of a 45-minute interview with that 6-year-old, I couldn't nearly cover all that information. This is a list, more of a list generated through the literature, and these are risk factors, evidence-based risk factors that put kids at high risk for failing to disclose. So this would be, and again, I would encourage you to kind of consider this group of kids as well for second or supplemental interviews. So young kids, again, kids who have close relationship with the offender, kids who right at the get-go, at the start of a forensic interview, you see limited cooperation and limited engagement. These tend to be the kids that continue to not engage as the interview goes on. Boys, kids who come to interviews who haven't made a prior disclosure or an outcry, so kids who were seen because of maybe CP, maybe medical findings, maybe another witness statement. So those kids who haven't already said or made a disclosure are going to be at high risk for failing to disclose. And then, of course, kids who have unsupportive caregivers. So that's my fancy little picture of saying sometimes we have this kind of demographic of kids who might be the square block that can't fit into our nice, neat circle hole of the single session forensic interview.
Now, some people might be thinking, what do I do with these multiple videotape statements? And can I use each and every videotape statement in court as evidence? Section 715.1 of the Criminal Code does not preclude the use of multiple statements as long as the preconditions that I previously indicated, being under 18 at the time that the offense occurred, and the other preconditions are in fact met. The overriding principles remain the same, that it is a truth-seeking function, that we are trying to provide the best evidence to the court, and we're trying to prevent the re-victimization of these children. And if it's the case that it requires multiple interviews in order for the child to give an account of the offense and what occurred, then there is no reason why those multiple videotape statements cannot be admitted into court as evidence.
And as Debra and I were thinking through this webinar, I think the other thing that we now know very clearly in our field is that disclosure, and here we're talking about sexual abuse disclosure, but we've come to clearly recognize in our field that disclosure is an ongoing process. And in fact, dating back way back to 1983, Roland Summit had this clinical opinion that disclosure was an ongoing process marked by these various stages where kids would move through them, sometimes backwards, sometimes a step forward. So that initial clinical opinion that many years ago is now remains really quite true from our current research and typically from our own practice. We've come to recognize disclosure as an incremental process. We know that about 25 to 40% of kids will actually disclose during childhood, and of those kids that disclose, it is very, very common for it to be what we call a delayed disclosure. So they will have provided that information days, weeks, months, maybe years after the actual events. And then even when we capture kids into our system and kids are formally interviewed, we know the numbers are a little more mixed on this, but conservatively, we know that about a third of those victims will fail to disclose or will provide false negatives. So, with this in mind, understanding disclosure as a process, I think it's another important thing to think about when you're deciding about offering a child more than one opportunity to say something if they have something to say. One of the questions often is, why do kids fail to disclose? I don't think there is not one particular answer to that. It's very case specific and specific to that particular child and that particular situation. These are, some of the things that have been raised clinically and in research. I remember very clearly in a second interview with a child, asking a child, which I'm going to suggest when we get to kind of the more applied part of this webinar, I'm going to suggest that in a second interview that we always ask kids, I know before you spoke to me, you spoke to so-and-so. Tell me why you didn't talk to so-and-so about the disclosure. And I remember one girl said to me, she said, well, the offender, whoever that was an adult and I'm a kid, and who believes the kid over an adult? I didn't think that person would believe me because I was the kid. Something, as simple as that. And then I think the other thing to consider, which I've mentioned already, is that, in our interview context, for the vast majority of kids we're coming into contact with, these are kids that have been through generally traumatic kinds of experiences, whether that's DV witnessing, physical abuse, sexual abuse, peer assault. And we know clearly that kids don't necessarily come out of those situations unscathed. These are kind of more clusters of symptoms from a pediatric or child point of view that we know that kids will struggle with. Not all kids, but some. So just difficulty concentrating. A very typical trauma symptom is avoidance, that it's easier not to talk about it. So when kids in our interviews say, I don't remember, or I don't want to talk about it, or I'm not sure, it becomes tricky business figuring out how much of that is avoidance versus, them really not having a memory. And then also kids coming with what are more re-experiencing symptoms, and somatic complaints and anxiety because they're having some re-experiencing of the event as we're talking to them. I think the other thing I just want people to keep in mind in terms of deciding about doing second interviews or when second interviews should be done is that oftentimes some very important, significant events can happen in a kid's life in the time in between a first and a second interview. I mean, the typical example is if after the first interview, even with limited information from kids, if there's enough concern, I mean, some of those kids find themselves, apprehended and in foster homes. Sometimes the family system is disrupted and an offender needs to leave the home. And so things can look very different from the kids' world and the kids' perspective after that first interview is done. And sometimes that's to our advantage. There is sort of the belief that if kids are separated from an offender, their feeling of safety is more intact and they might be more inclined to be frank and provide additional information. But we also know that the very opposite is true. We know that sometimes when kids are placed in foster care, that presents a risk for recantation. So again, it's an important thing to sort of keep in mind when you're thinking about your cases on a case-by-case basis. For this child, what's happened since that first interview? And are things in place enough that a second interview might be productive? I was going to show you another video clip here, which I can't, but this was just a 13-year-old girl who was being interviewed by one of my colleagues from Toronto Police. And it was, I wanted to sort of show you an example of this young girl who had been interviewed initially and really provided, I wouldn't even say a partial disclosure. She had actually been found in a hotel room with a 27-year-old man. She was 11 at the time. And obviously based on the age difference, as well as some chats and images that were found on some social media that they were corresponding over, the police were able to go ahead and lay some charges. She then, but in her interview, she did not disclose anything that the police were able to pull off social media. And she didn't provide any disclosure aside from the fact that she had met this guy on whatever social media site it had been and that she had agreed to meet him at this hotel on that particular night. About 2 weeks before the preliminary hearing, she, with her supportive caregiver, who was her dad at that point, actually contacted the officer in charge and said that she wanted to do another interview and give another statement. And in the second interview, she gives pretty good disclosure around sexual assault. And what had happened to this kid in the interim is that she had gone into treatment, she had gone into counseling, and she had been able to get a little bit of a different perspective of what it meant for an 11-year-old to have a sexual relationship with a 27-year-old man. And in the clip, she describes, getting this different perspective, which allowed her to provide this information to the police.
Now, luckily, the courts do recognize that there's no connection between the timing of a complaint and the genuineness of a complaint. Back in 2000, the Supreme Court of Canada, in the decision of DD, noted the following, and this was written by Justice Major at the time, that there's no specific rule as to how individuals who are victims of trauma like sex assault will behave. Just as Meredith has already noted, some individuals will make an immediate complaint, while some will delay in disclosing abuse, and some may never disclose. And some of the reasons for this, and this has been recognized by the courts and continues to be recognized by the courts, are that there are a variety of reasons why people don't disclose immediately. And those may be embarrassment, fear, guilt, lack of understanding, and knowledge. the background to this case involved whether or not expert evidence was required to be called in order to explain delayed disclosure. And the view was that expert evidence is not required to be called. As I've already indicated, the courts recognize that there is in fact delayed disclosure. The next sort of step and question then would be not just delayed disclosure, but incremental disclosure. So cases where a child, a victim, will disclose some things in a first statement, but only disclose other things later on. And the courts have viewed this in a similar way to delayed disclosure, such that there is essentially no connection between timing of the complaint and the genuineness of the complaint. And again, in those circumstances, expert evidence is not necessary or needed to be called by the Crown to explain this to the court. That doesn't mean that expert evidence may never be needed. There may be some cases where there are some significant inconsistencies or recantations in the disclosure by a complainant, and in those circumstances, it may be the case, following a voir dire, and if in fact the test for expert evidence is met, then an expert may need to be called. These cases, however, are different than the cases that I previously mentioned, where a victim doesn't disclose right away for a variety of reasons, or discloses in an incremental fashion.
So, other thing I want to talk about just briefly is what we know about memory. One of the things we do know about memory is that a process called reminiscence, which is really our attempt at trying to retrieve a memory from our memory storage. So what we know is that typically an initial scan of your memory when you're asked about something typically doesn't allow you to retrieve and collect all the information you have stored about that particular event. And that additional sweeps, you can see my sweeping kind of picture here, is beneficial in terms of the fact that those retrieval attempts act as sort of a form of review and allow us as adults and as kids to typically access more complete information. So we're going to do a little test. We're going to take this back to this experiential exercise. So now I want people to think back again, pull their sheet out where they jotted down what they had done on July 1st, 2018. I want you now to do this again. Think back to July 1st, 2018. Please try to remember everything you did that day from the beginning of the day all the way to the end. And just to cue you a little bit more, I want you to remember that it was a Sunday. The World Cup was on. They were on round 16. Maybe think about where you were, who you were with, what you had to eat. And you literally have 5 seconds now. So my interest would be whether or not anybody was able to add information on their second. That was your supplemental interview, your second interview, hopefully another memory sweep with a few extra cues. I have to keep moving along. So this is kind of more the applied part of our webinar. So I'll try to keep moving because I know a lot of times people are interested in the application. So considerations for conducting second or supplementary interviews. In my mind, it is completely essential if you are going to conduct a second or supplemental interview with kid, you need to review the initial interview. Because what you're not wanting to do is to do a complete replication of the first interview in the second interview. They need to look different to a certain degree. And if it's going to depend on the circumstances, but if the circumstances allow, it really is better to ensure a short period of time in between the two interviews to again capitalize on any rapport that you've established with the child, as well as getting people to do that re-sweep of their memory closer in time to perhaps encourage more thorough memory retrieval. I mentioned this already. If the child does provide disclosure in the second interview, always ask them about their decision to report, to tell you about it then. What made you decide to tell today is a good question. Because I haven't sort of been called on this in court, but I think it could again be an issue. Well, this little Sally, 6-year-old Sally, was asked all these questions in the first interview. Why didn't she say something then? I find kids usually have very, very good responses to this. I was scared. I wasn't sure I was going to be believed. I didn't feel comfortable. There could be a range of different things that kids will tell us. And then just again, this is all a second forensic interview obviously also needs to follow the best practice forensic interviewing guidelines that we have in our field. So some considerations for kids who would be classified more as reluctant kids. So these kids typically that I mentioned before, these are the kids that typically will have something to say, but for whatever reason have decided they're not able, willing, or going to have that discussion with you on that particular day. So in your first forensic interview, you might, if you're following sort of some kind of protocol-based interview, you're going to do an introductory phase, you're probably going to do ground rules, interview instructions, and then you're probably going to go into a practice interview, a rapport building section of your interview. Right at that point, you can often start getting a clue or some cues from these kids. Maybe not as clear as the pictures I have up here on the slide, but these are often things that interviewers have to read. So these are kids that aren't making eye contact, they're not really giving you much response, they're hiding under the chair. If you feel that at that point where you've done your interviews, your introductions, your interview instructions, and your practice interview, and kids they haven't engaged, they're really not giving you any multiple word responses, you're having to use yes, no questions, this is the recommendation. This is the revised NICHD Protocol 2014. It's actually found on the website listed here on the slide. So the suggestion is, if during the pre-substantive phase the child is not cooperative and remains reluctant, end the interview and schedule an additional interview for continued rapport building. And I know this often goes against our grain because we feel this is our job. We're here to do that interview. We have to keep going. We've set aside this time to do it. We have 4 other interviews to do or another investigation to pick up. But if your persistent questioning is not going to get you where you want to go, or more importantly, give this kid a fair and a good opportunity to say something, then I'd like people to consider stopping the interview and rebooking it another day. This is some research around what we know happens when we persist, when a child remains reluctant. We know basically that we get a little bit frustrated. I mean, we might not show that, but what happens typically is we provide fewer supportive comments to these kids, and we prematurely move to the more option posing, the yes, no questions, and sometimes even suggestive questions, because we feel we need to help these kids and we have to move them along faster. And so at the end of the day, we end up using kind of suboptimal interviewing techniques, and then we get suboptimal kind of information from these kids. So if things look like they're going sideways, that engagement's not happening right from the very beginning, really consider that ending the interview and rebooking.
And why that is so important is because come trial, in order to use something like Section 715.1 of the Criminal Code to admit the videotape statement in as evidence, or the preliminary inquiry to use Section 540, but specifically 715.1, the child must adopt that statement in the course of their testimony. Sometimes we're able to get a videotape statement from the child, but come trial, the child is unable to testify, or unavailable or unwilling to testify. It may be that the child is suffering from a trauma which doesn't allow them to participate in the criminal process. And in those circumstances, a good statement, and whether it's one statement or multiple statements, are very important, because we can use those statements as evidence if the statement is necessary. The statement becomes necessary if the witness is unable to testify, or more importantly, the statement is reliable. And in determining the reliability of the statement, we look at the circumstantial guarantees of trustworthiness of that statement.
All right, and just for the last 3 or 4 minutes, because we're going to leave 5 minutes for questions, I'm just going to go over through a couple of cases. These are what I call the partial disclosers. So these are kids who may initially come for an initial interview and provide some forensically relevant information, enough just to make you concerned, to make you feel like you have to keep digging a little bit further to truly understand what's happened to this child. So this is a 6-year-old girl. She was overheard by her paternal aunt telling a similar age cousin that she got to see Uncle Mikey's penis. The 6-year-old repeated this to her mother later that day, and then upon hearing it, Mom got quite emotional and upset. Mom then contacted the police. So during the first police interview, the 6-year-old girl did disclose that Uncle Mikey had exposed his penis. And at the end of the interview, while she was describing in a little bit more detail her contact with the suspect, she started, it's quite like an out of the blue statement, and I don't want to play that doctor game with him anymore. The interviewer, the police officer in this case, tried many different ways to get her to elaborate and expand on that and describe that in more detail. But truly, they were about 45 some minutes into an interview already when that statement came out, and I think this kid was to a certain degree fatigued. So during what I have here on the screen is on the left side, you'll see sort of the protocol that was used with her in the first interview, and then what I did in the supplementary interview. So you can see that the introductions, interview instructions are done, and the practice interview and report is done in the first interview with this child. What I did in the supplementary interview is I introduced myself. I'm a different interviewer, a different face to this child. I did not with her repeat all the interview instructions. I asked her what she remembered about the rules about talking in the room, and very bright kid, she was able to actually name them all off. And then I did a much sort of shorter practice interview rapport building with her, because I felt she was engaged quite quickly on. In the first interview, in terms of transitioning to the substantive issues, she was initially asked, what are you here to talk to me about today? Tell me about your family. I heard you were playing with your cousin a few days ago. Tell me all about that. Is your mom worried about something or sad about something? So with these prompts, the information came forward around the penis exposure, as well as playing that doctor kind of game. In my supplemental interview, I didn't necessarily need her to repeat about the penis exposure, but I did feel, I think in the second interview, in the supplementary interview, I routinely still asked that very broad, open-ended question, what are you here to talk to me about today, to give this child an opportunity to pick or decide what she was going to say. And then I typically say, we need to talk about the same things you talked to the first interviewer about, to again, as a way to sort of trigger her to again decide what information she's going to tell me about. And then pretty quickly, because this whole notion of games she had introduced in the first interview, I felt had a leg to stand on to move her in this direction pretty quickly. I mean, if she had given me information as a result of those first 2 prompts, as a good forensic interviewer is going to do, I would have, followed her through that and gotten her to expand and elaborate on that. But sometimes in these second interviews, if you're after fairly specific information that the child's already given, I feel that we have a little bit more, like I said, a leg to stand on to do that.